The judge in this case is the brother of a famous Hollywood director who once worked with Blake Lively. Hello, my friend. It is Perez, the queen of all media, the original influencer, and your number one source for everything It Ends With Us saga. I naively thought that Judge Lyman's relationship with his brother would have had no influence whatsoever on the proceedings in this case. I think I was wrong. I think Blake or Ryan somehow got to the judge. I've already made many videos today about this because I needed to understand the judge's thinking, and I've been working my way through his ruling. Watch those videos to be fully caught up. If you're just tuning in, all of Justin Baldoni's claims against Blake Lively have been dismissed. The judge is giving him until June 23rd to file a second amended complaint, but only 2 of his 9 claims can move forward. All the other ones are done with prejudice. Over. I shared with you already all the reasons why Judge Lyman did not believe the Baldoni Wayfarer's claims of extortion and defamation. Now he is going through the rest of the claims. False light. Painting him in a false light in the public eye. The law says that the false light must be highly offensive to a reasonable person. In addition, the defendant must know or act in careless disregard as to the falsity of the publicized matter and the false light in which the plaintiff would be placed. The Wayfarer parties cite paragraphs of the amended complaint alleging that Lively and her team selectively and deceptively edited text messages so that they portrayed a false narrative of a smear campaign. However, those factual allegations simply allege, in different words, the same conduct that is alleged to constitute defamation. The court has already explained why the Wayfarer parties do not state a claim for defamation based on these allegations. The Wayfarer parties cannot benefit by the expedient of simply relabeling their defamation claim as false light. Breach of implied covenant of good faith against Lively. The Wayfarer parties' breach of implied covenant allegations are conclusory. Meaning, a conclusory statement in law is a statement that makes a conclusion without providing supporting facts or evidence. The Wayfarer parties do not plead the terms of a relevant contract, which of the Wayfarer parties it was with, or when it was made. What? The Wayfarer parties' amended complaint contains vague references to contract negotiations or entitlements, but it also indicates several times that Lively did not sign her employment contract for the film. The Wayfarer parties do not allege any particular contractual provision that prohibited Lively from involvement in the production, editing, or marketing of the film. They therefore do not identify any contractual provision, the exercise of which Lively frustrated. The breach of implied covenant claim is dismissed. Tortious interference with contractual relations or prospective economic advantage. This is about the whole interfering with the agency that dropped Justin Baldoni. The amended complaint alleges that WME was Baldoni's agency, that Lively, Reynolds, Wayfarer, and Baldoni were represented by the same talent agency, and that Reynolds told WME that the agency was working with a sexual predator and demanded the agent drop Baldoni. However, the Wayfarer parties do not allege that they had contract with WME, the breach of which Reynolds knowingly induced, or any economic benefit that would have been realized from a prospective relationship with WME with which Reynolds could have interfered. They also failed to allege that WME was influenced by Reynolds' statements in any way, aside from conclusory statements that WME ceased performing, the relationship was disrupted, or the Wayfarer parties were harmed. This judge is clueless. Promissory fraud and breach of implied contract against the New York Times. Under California law, promissory fraud is a subspecies of the general cause of action for fraud. The plaintiff must plead the existence of a contract, the performance by the plaintiff, or excuse for non-performance, breach by the defendant, and damages. The Times emailed the Wayfarer parties at approximately 9:40 p.m. Eastern on December 20th, describing the allegations of the CRD complaint and asking for a statement, and their response to the allegations in the CRD complaint. The article was published the next day on December 21st. Prior to publishing, the Wayfarer Party's counsel then responded at 2:16 a.m. Eastern. The judge says, the Wayfarer parties have not pleaded the existence of a contract. The emails do not constitute a contract. There is no offer, no acceptance, and no consideration. The email sets a deadline of noon Eastern for comment, but it does not offer to hold publication in exchange for anything. The Wayfarer party's email does not accept any such offer by the Times or even indicate any further comments are forthcoming. It simply provides comments. The Wayfarer party's theory is apparently that by sending their comment, they accepted an offer from the Times that they would have until noon the next day to comment. The article was published before noon at 10:11 a.m. Eastern. The judge says once the Times had the Wayfarer party's comment, it would not need to wait until noon for an additional comment. Also, a request for information before a certain time is not a contract. Moreover, if there was a contract, it was satisfied. There was no breach. So the promissory fraud claim, done. And here is the craziest part. As Justin Baldoni's attorney has said repeatedly, throughout the course of discovery, which has been going on now, they have gained new evidence against Blake Lively, Ryan Reynolds, and her publicist Leslie Sloan. However, when explaining his ruling today, Judge Lyman said, quote, "When a motion to dismiss is granted, the usual practice is to grant leave to amend the complaint. However, it is well established that leave to amend a complaint need not be granted when amendment would be futile." That's all in quotes because that is law. The judge says, in his own words, "The court will not grant leave to amend the majority of the Wayfarer party's claims because amendment would be futile. The dismissal of claims does not rest on technical pleading defects, and the Wayfarer parties have not made a showing that the complaint's defects can be cured. The Wayfarer parties do not identify any particular factual allegations that could be added to support the defamation or civil extortion claims, nor is it possible that any allegations not yet mentioned would change the basic substance of Lively's threats, the conclusion that the CRD complaint was privileged, or the conclusion that relevant statements were made without actual malice." In addition to their 224-page amended complaint, the Wayfarer parties have already submitted to this court an additional 168-page exhibit with additional details relevant to their claims. Although the exhibit is not properly considered for purposes of the motion to dismiss, the allegations within still would not allow the Wayfarer parties to state a claim. The exhibit contains additional detail on Lively's threat, but if anything, these details cut against a finding of extortion. Given that the Wayfarer parties have already provided an extensive record of facts that purportedly portrays their claims in the best possible light, the promise that more unspecified facts will now change the central aspects of their core claims suggests a move to extend the litigation rather than a legitimate belief that amendment will alter the court's determination. The judge says he's heard enough to know that nothing will change his mind and that they are without basis in the law. They are wrong, they are right. End of story. But he can amend on those two claims that aren't even that strong. Crazy, crooked. Thoughts? Let's discuss everything in the comments.